Morning.
May I please, the Lordship? Lordship, I'd like to mention item number 17, Lordship.
17.
Lordship. Here, the state respondent is here to file affidavit in opposition, Lordship.
Mm.
So, Lordship, may please to grant another 3 weeks time to file affidavit in opposition.
State respondent is respondent number.
Respondent number.
You don't have the brief. Anyway, item 17. Yes.
After 4 weeks.
You're asking for time or the state is asking for time?
I'm for the union of lordship.
You also haven't filed.
No, the, in the cost list, there was a mistake.
Mm.
So after rectification, I have taken first step. So let it come after 4 weeks on behalf of the union.
Praise made by Sri Gauhati, learned CGC for respondent number
Two.
two. For 4 weeks in order to file his affidavit in opposition. So learned government counsel V. Zimomi has also prayed for time to file the counter affidavit on behalf of the state respondents. Prayers allowed. This is the matter after 4 weeks. The councils shall file their counter affidavit in the meantime. So
Lordship, may I also please pray for item number 12 to 15. These are items matter. I have not received instructions so far.
12 to
15.
15. Petitioner is there.
My lord.
Learned counsel for the petitioner, I. Jamir is present. Stop. Mr. Yangarwati, learned CGC, prays for how much time?
3 weeks, Lordship.
3 weeks to file his affidavit in opposition. Praise allowed. List the matter after 3 weeks.
I'm sorry, Lordship. In item number 17, my
Yes.
name may be reflected, Lordship. I have just mentioned in the
Pattern number. Oh, yes, yes. In item 17, the registry is directed to reflect the name of Sri Yangarwati CGC as counsel
Respondent
for
number
the
two.
for the respondent number 2 in the cost list.
Mr. Lordship,
Yes.
Lordship, I'd like to mention item number 16. Lordship, here, I've received the instructions, Lordship, and it's under preparation, so can you grant me some time, Lordship?
You are government advocate.
Lordship, for the
Okay.
state respondents.
Learned government counsel, MS such and such, prays for how much
3
time?
weeks time,
3 weeks
Lordship.
time to file the counter affidavit on behalf of the state respondents as the instructions has been received. Learned counsel for the petitioner is present. Stop. Prayers allowed. List the matter after 3 weeks.
Much obliged, Lordship.
May I bless Lordship.
Yes.
Lordship, I beg to mention item 8.
8.
I'm for the petitioner, Lordship.
Hmm.
I'm filing my affidavit in replies to the affidavit of associations. So, today, Lordship, I'm filing it today.
Okay.
So, may I be this matter listed for hearing and usual course, Lordship.
To the counter of the state respondent.
State as well as the private respondents.
Item 8. It is stated that the state respondents as well as the private respondent number 5 has filed their affidavit in opposition. Accordingly, the learned counsel, Mr. Wati Jamir, for the petitioner has prayed for time to file his affidavit in reply. Prayers allowed. List the matter after 1 week
Lordship,
2 weeks.
I'm filing my replies today, Lordship,
today. So 1
during the
week.
course of the day. So,
So
let
we'll see
me
1 week.
place for hearing, Lordship. In usual course.
You file it first.
Lordship.
It's okay. List the matter after 1 week.
Yeah, Mr.
Yes,
Lordship.
yes.
Lordship, I'd like to mention item number 11 on behalf of my colleague.
Mm.
We have filed, Lordship, if this matter can come out after a week.
We're mentioning on behalf of
Achungli.
mention is made on behalf of MS Achungli government advocate that you have to file counter.
Well, we
You
have
have
filed.
filed?
we
You have
filed,
already
Lordship.
filed.
Your Lordship.
Then we can put it for hearing.
So this matter can be disposed of, so if it can be
Then 1 week
1 week.
for adjournment for 1 week. Learned counsel for the petitioner is present. List the matter after 1 week.
Much
Lordship.
obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 5. Here state is yet to file affidavit, Your Lordship. I'm yet to receive the parawise comment, so kindly grant me some 3 weeks time to file the affidavit.
Petitioner. Yes. Learned government counsel, Ms. Such and such has prayed for 3 weeks time to file the counter affidavit on behalf of the state respondents. Learned counsel for the petitioner is present. Prayer is allowed. List the matter after 3 weeks.
Much obliged, Your Lordship.
Lordship, I beg to mention item 18. I'm yet to
18.
file my rejoinder affidavit. Kindly grant 2 weeks time, Lordship.
You're appearing for
I'm the petitioner, Lordship.
petitioner, okay.
Yes, Lordship.
How much time?
2 weeks time, Lordship.
2 weeks to file reply.
Yes, Lordship.
Ms. Nolovulio, appearing for the petitioner, has prayed for 2 weeks' time to file a reply to the counter affidavit of the state respondents. Prayer is allowed, list the matter after 2 weeks.
Thank you, Your Lordship. I beg to mention item number 6.
6.
Yes. I'm appearing on behalf of my senior counsel. This matter has been fixed for admission hearing on 13 March, but on a later date, it has been fixed to file additional affidavit. But since my senior is not filing the additional affidavit, may this matter be called off for today and then be fixed for admission hearing tomorrow?
You're not going to file the additional affidavit?
Yes, Lordship.
Okay. Can I just see the record once? You had prayed for time to file additional affidavit.
No, Lordship, we won't be filing for
No,
additional
no,
affidavit.
earlier, but
I-
now you don't want to file.
Yes, Lordship.
Additional affidavit or affidavit in reply?
Reply.
Reply. Heard learned counsel for the petitioner. You are
Chivovela.
Chivuvulu Raklo.
Yes.
Yes. Who submits that on earlier occasion, this court had allowed time to the petitioner to file the affidavit in reply. Stop. However, on instructions from her senior counsel, the petitioner submitted that they are not going to file the affidavit in reply, and therefore the matter may be kept for admission hearing. On when?
Tomorrow.
Tomorrow. On another date. Stop. Pass over for the day.
No, please, Your Lordship,
Yes.
I beg to mention item number 9. Can we grant 3 weeks time to file affidavit in reply?
3 weeks time.
Yes, Your Lordship.
You're mentioning on behalf of Mr. Ari Ralo,
Yes, Your
Adjournment counsel for the petitioner, Ms. Such and such, submits that she would like 3 weeks time to file the affidavit in reply.
Yes.
Learned government advocate is present. List the matter after 3 weeks.
There is an interim.
The interim order passed earlier shall continue till the next date.
I may also be allowed to mention hearing item 24. My senior have difficulty today. Kindly list the matter after 2 weeks.
On instructions of the senior counsel, Mr. L. Iralu. L. Iralu or R. Iralu?
L. Iralu.
Oh, okay. On behalf of her senior, R. Iralu, mention is made to list the matter after
2 weeks.
2 weeks, as Mr. L. Iralu has some personal difficulties today. List the matter after 2 weeks.
There is an interim.
And interim order passed earlier shall continue till the next date.
Much obliged.
Anything else?
Your Lordship, I beg to mention hearing item number 23, if this matter may be listed after 2 weeks.
23. Any objection? Learned counsel for the petitioner has prayed for listing the matter after 3 weeks.
2 weeks, Your Lordship.
After 2 weeks. Learned government counsel and private respondent is also there. Okay, and counsel for the respondent number 3 has no objection. List the matter after 2 weeks.
Much obliged, Your Lordship.
Yeah, please, Your Lordship. I
Yes.
beg to mention item number 3 in the motion list, Your Lordship.
Mm.
My senior has some difficulties today, so if the matter may be passed over,
For the day,
yes, Your Lordship.
item 3. Pass over for the day as Mr. Jimomi
Yes, Your
has
Lordship.
some difficulties today.
Lordship, I beg to mention item 10 as well.
Yes.
Can you grant us
item
3 weeks time to file a reply?
Reply.
Yes, your lordship.
Item 10, learned counsel for the petitioner is paid for 3 weeks' time to file a reply to the affidavit in opposition of the government respondents.
No, your lordship, for respondent 5.
In reply to the counter affidavit of respondent number 5, okay? List the matter after 3 weeks.
Yes, your lordship.
3 weeks.
For motion, item number 1.
May it please your lordship. May I pray your lordship may kindly take up item number 2 as your first item, your lordship. Both arising from the same FIR, your lordship.
50,
Item number 2.
50.
The allegation against me under section 420, 406 and 138 of the Negotiable Instrument Act, your lordship. Lordship may kindly peruse the FIR at page 15. May I read your lordship?
Page
15. May I read your lordship?
yes.
With reference to the subject cited above, I'd like to lay down some few lines of prayer for your kind perusal and immediate necessary action, please. I'm leaving that part, your lordship. Mukesh Chaudhary is the accused petitioner here, lordship, and Wasif Rahman. Gauhati had approached me and our proprietor Unique Motor Madan Sharma to supply Mahindra and Mahindra for spare parts distribution and took a security deposit on 2 occasions dated 28/12/2022 and amount of rupees 55 lakhs. Only billing receipt number so and so dated 26/4/2023 and amount of rupees 15 lakhs. Only billing receipt numbers so and so. However, they have failed to supply the materials as neither promised by them nor had refunded the amount taken by them till then. That they have given check in favor of the Unique Motor accounts on 2 occasions, that is check number so and so dated 2/7/2023, amount of rupees 40 lakhs, and check number dated so and so dated 28/8/2023, and amount of rupees 35 lakhs. Check were bounced back due to insufficient fund when I went to withdraw the said amount. Hence, it is done with malicious intention on their part to dupe me and Unique Motors. In view of the above, I am requested to esteem authority to kindly take necessary action against them for cheating me and book them under appropriate sections of law so as to recover the amount which I have invested. Now, the facts, your lordship, are partly true and partly not true, your lordship. Yes, it was not them.
Where is your name here? This Mukesh
Mukesh Chaudhary, your lordship. I am the one who has issued the check. Lordship, I have categorically stated in my petition at page 4, your lordship may kindly paragraph 3.2. 3.2.
Yes.
May I read, your lordship? The informant came, had your lordship got it, your
Yes,
lordship?
yes.
The informant came and met the accused petitioner at Gauhati with one of his friends. Now, may I pause for a moment, your lordship? This friend is the petitioner in the item number 1.
14.
Item number 1. Except this, his role, there is no role, your lordship. In the last week of December 2022, the informant told the accused petitioner that the informant is the manager of Unique Motors so and so, and there is very high demand of the spare parts of Mahindra and Mahindra vehicle at Dimapur. Hence, the informant requested the accused petitioner that if the accused petitioner can manage some person or persons who can supply spare parts of Mahindra and Mahindra vehicle at low price, the informant is ready and willing to purchase the same. The co-accused Wasif Rahman was also present in the said meeting, and the co-accused Wasif Rahman categorically stated to the informant that the co-accused Wasif Rahman has close relations with many persons who work in Mahindra and Mahindra Gauhati. As the co-accused Wasif Rahman will be able to supply the spare parts of Mahindra and Mahindra vehicle at a low price to the informant, but the informant have to pay the money in advance. The informant immediately agreed to the said proposal of the co-accused Wasif Rahman and agreed to pay an amount of 70 lakhs. It is noteworthy to mention here that although the informant agreed to the said proposal, however, the informant requested that he will pay the advance amount if 2 checks are issued by the accused petitioner as security checks in favor of Unique Motors. The accused petitioner immediately refused the said proposal. However, the informant and the accused petitioner Wasifur Rahman persuaded the accused petitioner to stand as a guarantor and to issue 2 checks as security checks. In fact, the co-accused Wasif Rahman also promised that he will give 2% of his total profit to the accused petitioner every year. In the month of April 2023, the co-accused Wasif Rahman had informed the accused petitioner that the informant had paid an advance amount of rupees 70 lakhs, and in the month of May 2022, the accused petitioner had issued 2 blank checks as security checks in favor of Unique Motors. In the month of February 2024, the co-accused Wasif Rahman had paid an amount of rupees 1,80,000 to the accused petitioner. That is the 2% of the 12 earned profit by the co-accused Wasif Rahman. The accused petitioner said the accused petitioner is under a bona fide impression that the co-accused Wasif Rahman was supplying the spare parts of Mahindra and Mahindra vehicle at a low price to the informant. But the accused was totally shocked when in the last week of March 2025, the police person of Dispur police station had visited the residence of the accused petitioner and informed his family members that the accused petitioner is being directed to appear before the investigating officer of West Police Station, case number so and so. I'm ready and willing to cooperate with the investigation of the case, Your Lordship. I had issued the checks. They could have filed a case, a complaint case against me under section 130 of the Negotiable Instrument Act. They have not done that, Your Lordship. They have filed an FIR against me. I'm ready to cooperate with the investigation, Your Lordship. Some protection may be granted to me, Your Lordship. At this stage.
Okay, who accepts notice? We'll fix a date and then you get a scanned copy of the CD.
Yes,
Okay.
yes.
Yeah.
It's a case of documentary evidence, Your Lordship. The custodial detention of the accused petitioner may not be necessary in this case, Your Lordship.
We'll see. We'll consider when the.
Some
DD
protection may be
comes.
granted at this, Your Lordship.
Yes, interim
Well-
protection. This is an application under section 482 of the BNSS, praying for grant of anticipatory bail to the petitioner Mukesh Chowdhury. Okay, Mukesh Chowdhury. Stop. It is the contention of the learned counsel for the petitioner that where was the FIR? That an FIR dated 14/11/2024. 14/11/2024 has been lodged at the West Police Station, Dimapur, against the present petitioner. And a case has been registered, being West PS case number 022/2025 under section 420/406 of the IPC, read with section 138 of the NI Act. Stop. It is submitted that the petitioner is apprehending arrest in the said case, and hence the present application. Stop. It is also stated that the petitioner is willing to cooperate with the investigation and prays that he may be granted interim protection. Stop. Next paragraph. Learned BP. Shri
Tiangami.
Yangami enters appearance for the responding number.
So respondent.
Okay, you have not impleted the informant, no?
State of Assam, Your Lordship.
Okay.
State of Nagaland, I'm sorry.
Yes, State of Nagaland. Appears for the state respondents. Hence, no formal notice is called for. Stop. Let the matter be listed on.
Next week, Thursday.
We could give a fixed date.
15.
on
Next week,
15th, okay, on 15th May 2025, on which date the learned PP shall obtain scanned copies of the case diary and the latest and the status report. Stop. Till the next returnable date, it is directed that the petitioner, in the event of arrest, the petitioner shall be released on executing a bond of rupees 30,000 to the satisfaction of the arresting authority. Stop. And the petitioner shall also appear before the IO of the case. Stop. It is made clear that this interim protection is subject to the outcome of the petition hearing. Stop.
My
Very
lady,
grateful, Your Lordship.
my lady, if the petition may be directed to appear before on the specific day before the next returnable date.
Okay, and that, no, you just give a date. When can you appear? Monday,
Monday, Your Lordship.
Monday, on 12th.
Like,
Item number 1, Your Lordship, is the friend, Your Lordship. No, absolutely no allegation against him in the FIR, Your Lordship. I was the friend who visited along with the informant. I was working as a salesman, and I am also being called by
His
the.
name is there in the
His
FIR.
name is not
It's
there in
not
the
there.
FIR, Your Lordship. I worked as a salesman in Unique Motors, Your Lordship. I went there to meet the accused petitioner number 2.
Then where is the apprehension if you are?
No, Your Lordship, they have issued a
Or notice to you also?
notice to me also. That is why I'm apprehending. Some protection at this stage, Your Lordship. I'm ready to cooperate. Absolutely no role, Your Lordship, on my part.
Then in that case, same order, but towards the beginning, na, you just say, instead of saying that his name has been put in the file, no, just say that he's apprehending arrest in connection with West PS case so and so.
I'm very grateful.
Item number 4.
Maybe Lordship. Lordship, here the arguing counsel has some difficulties, Lordship. Lordship, if the matter can come up after 3 weeks, Lordship.
On behalf of the respondent, sir. No objection.
The, what's it called? For the appearing for the petitioner states that he is led by who?
Dr. Ankit Todi.
Dr. A. Todi in the present matter. And since the counsel is an out-of-station lawyer, the matter may be fixed on another date. Learned counsel for the respondent is present. So respondents, you're appearing for
All the
respondents.
respondents.
1, 2, and 3, no?
Yes.
1, 2, and 3 is present. List the matter when?
After 3 weeks,
A fixed
Lordship.
date.
After 3, list the matter after 3 weeks.
Lordship, there's an interim.
You
Can
don't
you
want
do-
a fixed date.
No, Lordship.
Interim order passed earlier shall continue till the next date.
Like much of
Petition item number 7.
Maybe so, Lordship. Lordship, I have received the instructions, Lordship. Can be allowed to place it. The petitioner's case has been complied with, Lordship.
Complaint.
Yes, Lord.
You have given a copy to the petitioner. You received it, no? We're disposing again then. Heard learned counsel for the petitioner, Shri such and such. Also heard learned counsel, learned government counsel. What's your name?
S. Chang, Lordship.
S. Chang. Also heard learned Miss S. Chang, learned government advocate for the state respondents. The petition has been filed, the writ petition has been filed by the petitioner praying for regularization of his service as per the office memorandum dated 17/3/2015. So it is submitted that the petitioner, Shri Jeb Bahadur, was appointed as work charge fixed labor under the establishment of the executive engineer, PhD, MON, with effect from 21/8/1989. Stop. It is stated that the government of Nagaland in the PNAR department had issued an office memorandum number AR-3/GEN-201/2009 dated 17/3/2015, which laid down the provisions that all existing work charged and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more of continuous service as on 1/1/2015 will be regularized by conversion of their post into regular ones personal to them. Stop. It is the contention of the petitioner that the petitioner has fulfilled the criteria of the scheme dated 17/3/2015 but his case has not been considered by the authorities till date. Stop. At this stage, the learned government advocate M.S. Chung has produced a copy of the office order number CE/PHE/EST-R-30/2016 dated 13th September 2024, by which the petitioner, by which the service of the petitioner has been regularized with effect from 2/1/2020. Stop. Accordingly, Learned Government Council submits that the petition may be closed as the prayer of the petitioner has already been complied with by the government authorities. Stop. The court has considered the facts and circumstances and the submissions made by the councils of the parties, and as the petitioner has already been regularized by the aforementioned office order dated 13 September 2024, nothing remains to be adjudicated in the present matter. Accordingly, the writ petition is disposed.
For admission, item number 19.
Yes, Your Lordship.
Yes.
Lordship, I beg to mention on behalf of MS Livica, Lordship, if previous time granted to file my affidavit in opposition, Lordship.
Learned counsel for the petitioner is present. Stop. Mention has been made on behalf of Miss Livica, Learned Government Advocate, for 3 weeks' time
Lordship.
to file, to receive instructions. 3 weeks'
Lordship.
time to receive instructions. Stop. Prayer is allowed. It is the matter of the 3 weeks.
Much obliged, Lordship.
Yes.
For orders, item number 20.
Your Lordship, service report is still awaited.
Only one respondent.
No, Your Lordship, 3 respondents.
Counsel for the petitioner is present. Office note dated 5/5/2025 indicates that service on the respondents is still awaited. Stop. Accordingly, it is the matter of the 3 weeks. Await service report on the respondents.
Your Lordship, there is an interim.
The interim order passed earlier shall continue till the next date.
Much obliged.
For hearing item numbers 21 and 22.
What happened to you yesterday?
My lord, my vehicle broke down
Oh.
in Naka Bazaar.
Okay, we were on 71, na?
My lord,
WP 71.
314,
Oh, 314.
that is disability pension.
Uh-huh. Yes.
What are they? So what I'm stating is that the authority have not considered about the disability, which was it was not a private clinic. It was a board.
Mm.
So in such an eventuality, what will happen is this. My lord. Extraordinary. Extraordinary petition. Rule 3. This is a edition 3A.
Rule 3. Okay. 3A.
My lord. Three A1, disablement shall be accepted as due to government service, provided that it is certified that it is due to wound or injury or disease, my lord, which is attributable to government service or
Existed.
A2 existed before or arose. It can be existed even before or arose during government service and has been and remains accredited thereby.
No, the thing here is, Mr. MT, if you had been continuing in service,
My lord,
you are very much like, I mean, you have to be given this disabled pension when you apply for it. But at that point of time, when you applied, you were already out of service.
my lord, I was,
They had already dismissed.
my lord, that is what they are trying to see. What I'm saying is that this court inquiry cannot be held in absence of the person who is
They have
charged.
to show that proper notice was given to you.
My
They
lord,
have to prove that proper notice was given to you. And if it was not given, then of course the court can interfere.
and my categorical statement is that the battalion was in Dimabor. The petitioner also stays in Dimabor. He was in touch with the unit all along. Only the thing is that he couldn't perform the duty. In over and above, the contact number which was used it that when he was in service. It is in the petition also, the same number. It never changed because he's not absconding this due to sickness. In my lord, HIV AIDS, is a serious ailment. That is why it has become not a state issue or national issue. It is an international issue. Then Section 20 of the Rights of Persons with Disabilities Act 2016, my lord. A parliament where it section 20, my lord. Section 20. Earlier, we had the same enactment, my lord, which was
Validity,
1995.
validity of certificate, this one. Section 20.
20. my lord.
Validity of certificate of disability issued under the repeat.
My lord, is it 2016?
Oh, sorry, wait. This is rules.
I'm on the act.
2016, okay. 20. Non-discrimination in employment.
Yes. 20. Bracket 1, no government establishment shall discriminate against any person with disability in any matter relating to employment, provided the appropriate government may, having regard to the type of work carried on in any establishment by notification subject to such conditions, if any, exempt any establishment from provision of this act. Bracket 4, my lord. No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her service. Who the act prohibits even assuming that there was a proceeding, it cannot be dismissed because the act is clear. Then, my lord, rules to allow it. Rule 17. Here it is. You are trying to see that the have acted up on the basis of these rules. Then
What rules is this? Assam Rifle.
some rifle rules 2010.
Mm.
Seventeen, chapter 4,
Yes.
termination of
Termination of
service.
service.
Authorities specified in the heading, column 3 to 6 of the table given below shall be competent to dismiss, remove, discharge, retire, or release a member of the force specified in the column on the grounds stated in the corresponding entries in column 2. In accordance with the procedure laid down in this chapter, in any power conferred by this rule or any provision of this chapter on any of the appointed authority may also be exercised by any other authorities superior to it, not below the authority. Provided that the provision of this chapter shall not apply to the persons on deposition with force, which is not applicable. So table is serial number, grounds on which service can be terminated. Roman 5. Physical unfitness.
Unfitness.
If it is officer, central government, IG, or in subordinate measure, and DIG in ADIG in case of enrolled person. The supplier are called enrolled person. Then retirement Rule 26. Rule 26. Retirement or discharge of subordinate officer and enrolled person on ground of physical unfitness. Where a commandant is satisfied that the subordinate officer or an enrolled person is unable to perform his duties by reason of his physical disability, he may direct that the said subordinate officer or enrolled person, as the case may be brought before a medical board. So it was a medical board.
Yes.
The medical board shall consist of such officers and shall be constituted in such manner as may be from time to time be laid down by the DG. 3, where the said subordinate officer or the enrolled person is found by the medical board to be unfit for further service in the force as the case may be, authority as specified in Rule 17. The dismissal is as per the rule. Authority is as per the rule. I accept that. If it agrees with the findings of the medical board, communicate to the said person the findings of the medical board. Interrupt within a period of 30 days of such communication, the person make a representation. In case of I want to make a representation against the finding. Competent authority supported by prima facie evidence or error of judgment in the opinion expressed by the medical board. In such evidence should be from government doctor or not below the status of civil surgeon, should contain specific mention that he has taken into consideration the findings of the medical board before giving his opinion. Where the person declared to be unfit for further service makes representation under 3. That is, in case of I make a representation, which I didn't. Same shall be forwarded to the next superior officer who shall have the case reviewed by a fresh medical board constituted for the purpose in order the retirement in discharge of the said person if the decision of fresh medical board is adverse to him. So once a medical board is constituted, in physically is category 3. That is why he was not. Actually, what happened is this: in the unit, in these armed forces, when somebody are detected with the HIV/AIDS, because of the psychological factor, they are not allowed to perform immediately. Because to handle any arms in ammunition, they are not allowed. At the same time, they cannot be given any other works also. So they are kept like it's somewhat like an isolation group. So when it is established that the medical board has recommended that he is not fit, and it should be, he should be either give in a supernumerary post or this Assam Rifles Regulation 2016, my lord. Pensions, it starts from Regulation 112, my lord. The rules for the grant of pension to Assam Rifle personnel, the rates admissible in procedure to be followed in dealing with pensionary claims as laid down in CC's Pension Rules 72. The following kinds of pension are applicable to Assam Rifles personnel. That is compulsory retirement.
Voluntary.
Next is voluntary retirement. Retiring pension. D is superannuation pension. E is provisional pension. F is invalid pension. G is disability pension. Assam Rifle personnel shall be entitled to disability pension under CCCOB rules. Whenever such a person is voted out of service for disablement attributable to government service or such disablement, my lord, arose.
During service.
Yes, during service, in remains aggravated thereby. The deed will not be applicable. The deed shall always be accepted due to government service where such deed is due to own injury or disease attributable to aggravated by government service. The amount of disability pension in such cases shall be determined with reference to the percentage of disability income. Then I
So you are saying that you will come under this G,
my lord,
disability pension.
my lord. When medical court proceedings is given in regulation 801.
Medical board proceedings.
My lord. Medical court proceeding invalidating medical court when the person subject to the Assam Rifle Act 2006 is reported as permanently unfit for service, the medical board will be assembled to carry out further examination. When the person is declared by the medical board to be permanently unfit for any form of service in the Assam Rifles, the proceeding of the medical board will be submitted through departmental channel to the DG Medical, Director Medical Assam Rifles for approval. If the findings of the board are accepted by the Director Medical, the board proceeding will be disposed of under the normal administrative instruction in the force. Invalidating medical board proceeding will be convened if specialist has recommended in his opinion that the person will be placed in factor 5. That is the worst.
Yours was 2.
3.
Oh, 3.
My lord. The authority competent to convene the medical board for involvement in the composition of involvement medical board shall be as under. That is, authority competent for medical board. A, Roman 3.
Respect of subordinate officer, DIG Composite Hospital. And director.
It was composite hospital, Sukubi, in the case of the patient. We have to continue with the next
Captain
petition.
Neha Sharma, RMO of 16 AR.
Oh,
Yours is shape 3. So
P
according.
three, yes.
Yes. So according to this, to be recommended for this disability pension, isn't it shape 5? As factor 5 of the shape factor. When a person subject to the is permanently unfit. Invalidated medical board proceedings will be convened if specialist has recommended in his opinion that the person will be placed in factor 5 of the shape factor.
One of the,
Because this medical board,
yes,
actually, it did not say that you are unfit. for
one of
duty.
the, that is what I'm trying to see,
Yes.
page 30,
Yes, page 30.
13,
Yeah, 13.
instruction, after 13,
Your petition.
yes. Page 30, after the petition,
Yes. The opinion of the board.
the instruction given to the individual by the president of the board. You are placed in low medical
Low medical
category.
category.
P3, that is T24. This is medical term which I don't understand.
And
have no
EL, earn leave, I think, earn leave for 24 weeks.
Low medical
Low medical
category,
category.
S1, H1, A1, P3,
P3.
bracketed T24.
Mm.
E1 for 24
24
weeks with effect from 18 March 2015 for principal disability, that is immune surveillance,
Mm.
subject to
Subject to
approval
higher
of
authority.
higher authority. From the proceeding, it is clear that it has to be approved by the higher authority, which we have not done. Oh, subject to approval of higher authority, intervening period up to the date of board to be considered as such and such.
So this is only for that period from 18 March 2015.
Malone, this is the medical board proceeding is as convened by the composite Hospital.
Composite hospital.
That is page 29.
Mm.
Authority ERCH is giving convening order. That inside.
Mm.
LMC A 1668 dated 11 January 2016.
But the date of board was 21st March 2016.
In one aspect of the matter, ma'am.
Mm.
Here, column 9.
Mm.
Cease duty on 18 March 2016. That is from 18
Column-
March 2016, column 9.
Ceased duty
Yes.
on 18 March 2016.
Ma'am.
So what you're trying to say is, another point is, in pursuance of this medical board opinion, you should have been recommended for this disability pension.
My lord. But from the proceeding, it is clear that subject to approval by
Approval
the
by
higher
higher authority, yes.
because medical proceeding was as per the order of the composite hospital.
Mm, mm. So finally, the opinion of the composite hospital, it should have gone to the director
My
medical.
lord, medical. That also should be sufficient, my lord. Because they have not taken into consideration of people with disability act 2016. Section 20.
Mm.
Now the petitioner is speaking.
But for such a long time, till your submission of the application, you were not getting your pay and allowances. You were just sitting at home.
He
Then what
got
were
up
what were you
to
doing? Huh?
2016.
Hmm.
Kita ada kas. August 2016.
Mm. That's right. From August 2016 till the date of your application, which is 17/8/2023,
Man.
you were not getting your salary. So why were you sleeping for so
My
long?
lord, see, the petitioner
Mm,
is not in proper frame of his mind.
mm,
It was his elder brother
mm.
who took some consultation from Mogokchung. Then only he was told that there is provision for them to keep their pension. PWD Act is very clear. Of course, all the, particularly the common people, they are not aware of the right.
Mm.
My lord, I am having this Swami's pension compilation.
Mm.
As you see, as this, the Supreme Court has decided about the disability
Mm.
developed when in
When in
service.
service. Mm.
Because,
No, there's no dispute about that.
my lord,
You may be entitled as per the medical board opinion and all that, since you contacted the sickness during service. But from 2016, when the board set, till this 2023, when you submitted your application,
my lord,
you didn't do anything.
no,
Oh, that is so such a big gap. 17, 18, 19, 20, 21, 22, about 7 years.
yes,
Mm. And you were not getting your salary that time.
no.
So you also did not inquire what happened to that board proceedings.
My lord,
Nothing.
actually, the
Mm.
establishment
Mm.
were since from the same unit.
Mm.
They were telling the petitioner to come in retreat,
Mm.
but they don't want to work
back.
anymore because of the sickness.
Mm.
That is how practically happened to see that.
Mm.
If it is, if somebody is a normal, healthy person, it is to be taken in that manner that if given up his service. But it's not that case. It is due to HIV/AIDS.
Okay. And your other petition is for?
My lord, subsequently, later on, when the petitioner applied for pension,
Mm.
he was informed that he was dismissed
Mm.
after a court of inquiry. If your lordship permits, I may allow to continue with the next petition, my lord. 71 of 2024. This is the state of affairs. What happened is this. Page 4, paragraph 3. The petitioner during the annual medical examination AME at Unit Hospital of 32 AR on 17/9/2014 was diagnosed with HIV positive with repeat test kit. He was prescribed medication and referred to Assam Rifles Composite Hospital, Sukhumvit by Dr. Vijay Bahan, 2IC, second in charge, CMO 32, Assam Rifle for special opinion, my lord. That is annexure 1, 2, and 3. Type copy, page 38.
This one we have seen. It is there in the other petition also.
My lord,
Yes.
then consent for HIV test. So they are saying that page 42.
Here you are challenging the dismissal order.
My lord, this right hand side may be same. When they rejected the application for pension, no documents were furnished. They just say that he was dismissed. This is my signature, the council signature, not the petitioner's signature.
Which one? Page?
Page 42, Annexure 11. Received by me on
Acha,
15/1/2024. And I handed it over to the petitioner on 16/2/24. And they're trying to see that it was a proceeding against him. This itself is sufficient, my lord. However, I may have to take your lordship to my petition.
Okay, that means during the pendency of this 314, you received this.
My lord.
So you challenged the dismissal order. Okay.
Otherwise, when they rejected my prayer for pension, no document were furnished. Of course, statement was there. Even this dismissal order was received by the council on 15/1/2024. So I may be allowed to read out my lord. 17 December 2019, whereas number such and such was referred to Assam Rifle Nodal Hospital, headquarters IGR South for medical treatment on 29 September 2016. That is from Composite Hospital. On 1 October 2016, the individual was further referred to RIMS by the medical specialist for further investigation. It Baptinath Diagnostic Center. This is a private clinic, but individual did not report back to Assam Rifle Noodle Hospital, headquarters IGR South, in absented himself without any information. The individual failed to report back to Assam Rifle Noodle Hospital and declared as deserter with effect from 1st October 2016 formal and still so absent. Then they are trying to predict two in wires number such and such. Enrolled in Assam Rifle on 8 September 2003. 3. In whereas after expiry of 30 days of his absence, a court of inquiry under Section 84 of Assam Rifle Act 2006 read with Rule 185 of Assam Rifles Rules 2010 was convened by the Commandant 32 Assam Rifle White Order number such and such dated 24 February 2017 to investigate it into the circumstances under which the number such and such our absented himself without leave in from Assam Rifles Nodal Hospital IGR South with effect from 1st October 2016 without any information is still so absent. The said court of inquiry declared number such and such deemed to be deserter with effect from so the deeming provision they have introduced it. In where such and such apprehension rule was also issued by 32 AR later number such and such dated 24A 2017 in respect of number such and such. To the SP Mohokchong, Nakalan to apprehend him, but till date he could not be apprehended and has neither surrendered to any Assam Rifle authority and is still absent. A total period of more than 3 years has elapsed since his absence, and a final notice to rejoin service was also forwarded to the individual with copy to NOK, next of kin, and OC, Mokong, Nakalan 532, Assam Rifle number dated 11 August 2019. Now, therefore, taking into consideration the entire circumstances of the case, I am of the considered opinion that further retention of numbers such as such in the force is not warranted. I therefore, by virtue of powers vested under section 11 bracket 2 of Assam Rifle Act 2006, read with Assam Rifle with Rule 17 in Rule 20 of Assam Rifle Rule 2010, dismiss such and such from service with effect from 17 December 2019. So, my lord, para 3.1. Petitioner has been under ART ever since his diagnosis. He was availing the ART medication from RCH Sukubi, as well as from District Hospital Dimabo. It is to be noted that ART treatment are provided free of cost to HIV patients by the government of India as part of its national AIDS control program since 2004. 3.2, petitioner was put under immune surveillance freeze with ERT number 541 of 2015 with an onset from September 2014. The report showed the petitioner's present medical category shape 1 and indicated that he was a patient on ART since 2015. The petitioner has been undergoing treatment here, RCH Sukubi, in undergoing various tests. 3.3, SHAPE is the acronym for that the unit hospital of 32 Assam Rifle, the medical board proceeding for medical categorization in sick leave cater office and ER personnel as authorized by the convening number such and such dated 11/1 of 2016 was held on 21/3/16, comprising of 3 doctors, that is, President of the Board, Dr. Rajesh Kumar, 2IC CMO of 32 ER, members, Captain Sneha Sharma, RMO of 15 ER, Dr. Brasad, Assistant Commander MO of 37 ER. That subject to approval by the authority. This is the proceeding. That according to the medical proceeding, the petitioner ceased duty on 18/3/2006 with principal disability immune surveillance. And the medical board placed the petitioner in low medical category, that is, we call it LMC. P3 bracketed T24 for 24 weeks with effect from 18/3/2016. The opinion of the medical board at the unit hospital 32 ER is as follows. Was the disability contracted in service? Yes. Was it contracted under the circumstances over which he had no control? Yes. Category is shape P3 bracketed T24 with effect from 18 March 2016. The instruction given to the individual by the president of the board, headed by the president such and such, read as follows. You are placed in medical low medical category for 24 weeks with effect from 18 March 2016 for principal disability, subject to approval of higher authority. Intervening period up to the date of court to be considered as physical treatment. That physical fitness is a crucial factor for the armed forces personnel in the fact that the petitioner was a rifleman general duty meant that he was on field duty throughout his service, which required him to be in fit physical conditions, especially in hard stations and CIT college counter insurgency areas, that is particularly Manipur in Nagaland, Malo. But from the medical court proceeding that is such and such, the finding is clear that the petitioner is in fact contracted the disability in service, meaning that at the time of joining the AR in 2003, the petitioner was medically fit and was without any medical infirmity in the HIV, was contracted in field service in duty. That office of the commandant here, 32 movement order did such and such, around 30 personnel mileage from the petitioner's unit who were under ERT treatment were made to procedural ARCH Sukufi for medical review. Accordingly, the petitioner reported to ARCH on 26/9/2016 for recategorization of immune surveillance. However, as the ERT medical specialist was not available as such, the petitioner, along with the rest of the personnel, was further referred to
16 a year.
I may be allowed to correct it. He called it not 16, IGAR. In the handwriting, I thought that it is 16 AR.
No, it should be IGAR South.
Yes, this is Assam Rifle Noble Hospital. Headquarter IGR South. That the petitioner accordingly report that it such and such for medical opinion and this 2IC CMO MD General Medicine IGR South referred the petitioner to the Papina Diagnostics in file for medical and laboratory investigation on 1/10/2016, my lord. Accordingly, the petitioner underwent a series of tests at the Papina Diagnostics on 2/10/2016, my lord. However, Papina Diagnostics, the CD4 cell count machine was damaged and not working. Therefore, the petitioner was further referred to RIMS in file for taking the CD4 test the next day. That is,
Treat them.
it is to be noted that CD4 cells are the white blood cells that fight infection, and CD4 cell count test is an indicator of immune function in the patient living with HIV. HIV positive patients have to regularly undergo the CD4 count to determine the number of cells in for the specialist to know if the current treatment is working for the patient or not. Accordingly, the petitioner had regularly been taking the CD4 cell count test at various clinics and hospital in Timabo. So instead of waiting for one night, 6/1, that the petitioner traveled with in part at his own expense, which included the cost of traveling both in accommodation. Since the 16 years out transit gain, there was no risk in for personnel from 32 AR because Nagaland is no. meaning that the personnel from North Battalion could not avail facilities such as ration and lodging. Therefore, after the death, it Papina diagnostic, instead of spending one more night, it impelled to undergo the CD4 test. It claims the next day, that is on 3/10/2016, the petitioner returned to Timor on the night of 2/10/2016 to take the CD4 count test. We need diagnostic. That is where he takes the normal and regular test, where he takes regular test. After the test result from diagnostic, diagnostic, the petitioner went back to South Nodal Hospital in Palu with all the medical reports, including CD4 count test result done in Timor. However, the medical specialist at South Hospital, who was supposed to review and check the report of all the tests conducted, was on leave. Referred was given by the specialist, but however, on third, he was on leave. That is why. So the petitioners showed this report to the CMO of 13th hospital, not the specialist. 6(2), that after returning from Assam Rifle Nodal Hospital, the petitioner went back to his own home at Tarukasan, Timor, Melo. That is where he stays. And since then, he's been under medical treatment for various HIV-related complications, including viral hepatitis and jaundice, held at Gideon Diagnostic Center, Timor, Rini Diagnostic Clinic, Timor, and City Hospital, Timor, which he is continuing held at Malo. Then the petitioner represented and such to the EI for invalid pension. Then it was rejected. And the predicts that there was an inquiry against it. Just see that it is a court of inquiry. The service dossier, the record, have to be looked into. No witness, even assuming that he is a deserter, then the witness is to be examined under oath. In their whole affidavit in opposition, what they have stated is that it was a semblance of a proceeding. Not accompanied with the proceedings. That till the receipt of the impugned office letter dated such and such, the petitioner was totally kept in dark about his dismissal from service, as he did not receive any communication notice about his dismissal. Only when the petitioner represented for pension, the respondent authorities informed that he had been dismissed from service with effect from 17/12/2019 formal. Then that by impugned order, dismissal order such and such dated 17/12/2019 passed by the brigadier DIGAR, the petitioner was purportedly shown to have been dismissed from service with effect from 17/12/2019 forenoon after a so-called court of inquiry convened by the commandant by order dated 24/2/2017 under Section 84 of the Assam Rifle Act, read with Rule 185 of the Assam Rifle Rules. In the so-called court of inquiry declared the petitioner to be a deserter with effect from 1/10/2015. At this particular point of time, he was into the Nodal Hospital for specialist opinion.
Yes, on 1st October.
Yes, and he reported on 3rd also, but they are saying that it is from 1. So I'm not on that 1 or 3. But
that no court of inquiry
No.
was held as per the rules.
no. It reads that the petitioner had no knowledge that he had been dismissed from service after a so-called court of inquiry was convened. After a lapse of more than 5 years since the petitioner's purported dismissal, the respondent authority furnished a copy of the impugned dismissal order dated 17/12/2019 to the petitioner's counsel. It is in the courtroom on 15/1/2024 without being accompanied by any supporting document or records. Practically, it makes no sense that a person is dismissed from service without a dismissal order in the first place. Thus, the action of the respondent authority is questionable, as the impugned dismissal order should have been furnished to the petitioner in due time. If told, the so-called court of inquiry was convened. However, in the instant case, the petitioner came to know about the existence of the impugned dismissal order only when the petitioner's counsel received a copy from the respondent authority. Thus, the respondent authorities have acted mechanically without the application of mind. Hence, passing of the impugned dismissal order by the regular DIGAR is stated in the Appellate Report and said, on this ground, that 32-year unit was stationed at Kashiram Dimabo, Malo. In the petitioner was in touch with the unit and kept the unit informed about his medical treatment. Not only that, the personnel of the 32 AR used to visit the petitioner, it is residence in Tarukagan, Malo, Dimabo, which was approximately only about 8.5 kilometers away from the unit. Assam Rifle unit, they used to keep on changing. That is, from the very beginning, it is in Kashira. It may be put on record that the mobile number of the petitioner is with the unit, which the petitioner still retains as to date. It may also be brought to the light that the 32-year was stationed in Kachiram Dimabor from 2015. Therefore, on 24/2/2017, when the so-called court of inquiry was convened, the unit was still stationed in Kachiram. And therefore, the respondent authorities could have communicated to the petitioner not only through phone calls, but could have taken the measure to visit his residence in serve notice for appearance before the so-called court of inquiry, COI, they call it. As such, terming and labeling the petitioner as a deserter with effect from such insight by the respondent authority in the petitioner purported dismissal from service is arbitrary, unreasonable, irrational, and unfounded. It is prejudicial to the rights of the petitioner and is liable to be set aside, Malo. Then this is the rule.
Mm.
10.3. That section 84 of the Assam Rifle Act, 84, no. There's different nomenclature. One is called overstaying leave, and one is absence without leave.
So here they have taken recourse to 84.
My lord, what does it see? Inquiry into absence without leave. That is exactly is the case with the petitioner. One, when any person subject to this act has been absent from his duty without due authority for a period of 30 days, a court of inquiry shall, as soon as practicable, be assembled in such court shall, my lord, on oath or affirmation administered in the prescribed manner, inquiry respecting the absence of the person and the deficiency, if any, in the property of the government entrusted to his case, or in any arms, ammunition, equipment, instrument, clothing, or necessities, and if satisfied of the fact that such absence without due authority or other sufficient cause, the court shall declare such absence in the period thereof in the said deficiency, if any, and the commandant of the unit to which the person belongs shall make a record thereof in the prescribed manner. 2, if the person declared absent does not afterwards surrender or is not apprehended, he shall, for the purposes of this act, be deemed to be a deserter. Then Rule 185, my lord. How the court of inquiry is to be held.
That is in the rules.
Rules. Rule 185.
Yes.
Court of inquiry when to be held. Numeral bracket 1. A court of inquiry may be held to investigate it into any disciplinary matter or any other matter of importance. 2. In addition to a court of inquiry required to be held under section 84, a court of inquiry shall be held in the following cases.
So where is it, the absence without leave? This is all natural death in cases where all injuries, financial regulations, misappropriation, secret documents. Here, the absence without leave is not mentioned. Court of inquiry. A is unnatural death. A2 is.
My lord, that is referred in this rule. That is section 84 of the Assam Appellate. That
Yes, that is there.
yes. So 84, what is 84 is inquiry into absence without leave. AWL. 1. When any person subject to this act has been absent from his duty without due authority for a period of 30 days, a court of inquiry as soon as practicable be assembled, and such court shall on oath, my lord, or affirmation administered in the prescribed manner, inquire respecting the absence of the person. In the deficiency, if any, in the property of the government entrusted to his care, or in any arms, ammunition, equipment, such and such, necessaries in if satisfied that the fact of the such absence without authority or other sufficient cause in the prescribed manner. Two, that is absence without any.
Yes, it says in addition to a court of inquiry required to be held under 84. So these are in addition.
Yes.
Rule 186 and 187. Rule 186 and 187.
Malo.
How
86 and
how to
87.
go about? Proceedings shall be submitted by the presiding officer.
Proceedings of a court of inquiry shall be submitted by the presiding officer to the officer or authority who ordered the court in such officer or authority on receiving the proceeding may either pass a final order or under proceeding if it is empowered to do so, or refer them to a superior officer. Copies of the court of inquiry proceeding, a person subject to the act against whom the COI has been given an opinion or who is being tried by a forced court on a charge relating to investigation by the court of inquiry shall be entitled to copies of the proceedings of the COI, except the findings in opinion draft, unless the DG, for reasons recorded by him, orders otherwise. Like then, para 11. That the respondent authority were in are fully aware of the petitioner's medical condition in that he was under medical treatment all along. Moreover, the respondent authority had all along been in touch in contact with the petitioner, but respondent authority opted not to inform the petitioner that the COI would be convened. That being said, the impugned action of the respondent authority is a blatant violation of Assam Rifle Act rules as well as the constitutional mandate. As the court, COI was convened without following due procedure. Hence, the action of the respondent authority is manifestly arbitrary and illegal, and therefore is not tenable in law due to the fact that the petitioner was not served with initial cause notice, nor was he given any opportunity to represent himself. Thus, the entire COI proceeding is vitiated and not sustainable in the eye of law, hence liable to be treated as none as an issue. Then Rule 183. Procedure of court of inquiry is laid down in the rule. 183, procedure of courts of inquiry. 1. The proceeding of a court of inquiry shall not be open to the public in only such person may attend the proceeding as are permitted by the court to do so. Just like departmental proceeding as well as criminal proceeding, Malo. 2, but one aspect of the matter is this. The rules are not only for penalty, Malo. To ascertain what happened to one of their employee. So they have taken it as a penal provision. The evidence of all witnesses, my lord, shall be taken on oath or affirmation and signed by them after the same has been read over and explained to them. Take it that I am a deserter. But
this
the
procedure-
witnesses to be examined under oath. Explanation, the court shall administer the oath or affirmation to the witnesses as if the court were a false court, my lord. Evidence given by witness shall be recorded in narrative form unless the court consider that any question in answer may be recorded as such. Or the court may take into consideration any documents even though they are not formally proved. That is, the documents in respect of the person whose case is being inquired into. The court may ask witnesses any question in any form that it considers necessary to elicit the truth, my lord. It's not only penal to find out the fact. It may take into consideration any evidence, whether the same is admissible under Evidence Act 1872 or not. Only the difference is no counsel or legal practitioner shall be permitted to appear before a court of inquiry. 7. Provision of section 111 shall apply for procuring the attendance of witnesses before the court of inquiry, like in the other court. Then, close it. Roman 1. Save in the case of a prisoner of war, my lord, this is important. He's not a prisoner of war. Who is still absent whenever the subject matter of inquiry is the conduct, character, reputation of a particular person. Such persons shall be associated throughout with the inquiry and be given full opportunity of making any statement or giving any evidence he may wish to make or give. And of cross-examination of any witness whose evidence, in his opinion, affects his character or reputation. 2. Roman 2, in other cases, before giving opinion in the case any person subject to the act, the court shall afford that person the opportunity to know all that has been stated against him. Cross-examine any witness who has given evidence against him and make a statement and call witnesses in his defense. Like in the criminal proceeding, the person himself can be the lone witness. Nine, the court may be reassembled as often as such and such meeting for the purpose of examining additional witnesses. All along, this is witness. Or further examining any witness or recording further information in such a case, the court may record fresh opinion if considered necessary after complying with the provision of clause 2 of subrule 8. So I've extracted in my petition only Rule 183, Subrule 8, Roman 1. That Rule 183 is clearly laid on the procedure to be followed while convening court of inquiry. In particular, clause 1 of Subrule 8 provide that no court of inquiry can be conducted in convened without the presence of the person whose conduct, character, or reputation is the subject matter of inquiry. Therefore, by not giving the petitioner an opportunity to be heard in representing himself before the so-called court of inquiry, the respondent authorities have violated the principle of alteram partem. In thus, the imputed dismissal order dated such and such passed by a regular DIT on the basis of so-called court of inquiry should be treated as non as ab initio, my lord. That apart from not following the procedure as laid down under ERA, it rules for convening a court of inquiry till date, the petitioner has also not been supplied with any copy that is including in the present writ proceeding of the proceeding of the so-called court of inquiry as mandated by Act and the rules. That Rule 187 of the Assam Rifle rules provide copies for furnishing it. My lord, you have already
That
noted
we've already
it. Yes.
seen.
That in the case of Sri Om Tota Sharma versus Union of India, High Court of Manipur decided on 19/1/22. It is observed that there.
If you have not annexed, then you supply the copy.
My lord, that in the case of Sri Om Tota Sharma versus the Union of India and others, the PPC number 138 of 2018, High Court of Manipur decided on 19/1/2022. It was observed. 26, in the instant case, failure on the part of the concerned authority not furnishing the findings in opinion of the court of inquiry to the petitioner has not been properly explained by the respondent. It is the faculty of the authority concerned to furnish the findings in opinion of the court of inquiry before awarding punishment. If we need to the delinquent so as to enable the delinquent to make a representation, the petitioner has been denied in perusing the findings in the opinion of the court of inquiry. Since the petitioner mainly questioned the validity of the impugned order contending inter alia that non-supply of findings in the opinion of the court of inquiry would reshape the impugned order, this court is of the view that the non-supply of findings in opinion of the court of inquiry to the petitioner is fatal to the case of the respondent in the given facts and circumstances of the case. The competent authority of the Assam Rifle has to provide all the relevant materials on the basis whereof the impugned order of imposing penalty of censure was issued. It was a question of censure only. Therefore, the non-supply of the relevant materials to the petitioner is deprive his right of opportunity to know the adverse material against the petitioner. Through the petitioner has been illegally dismissed from service by the respondent authority without any application of mine. In the most capricious and whimsical manner, and is in total violation of provision of law in Article 311(2) of the Constitution of India, which clearly laid down 311.
It's okay, this one don't read.
My lord,
Then
the
your-
respondent authority impugned dismissal as such and such claimed that an apprehension rule has been issued by such and such later such and such. To the SB Mogokjong, Nakalan to apprehend the petitioner. The respondent authority has stated that the final notice to return was issued to the petitioner into the NOK to the OOC by such and such. That till date, the petitioner has not been in receipt of the so-called apprehension rule or the final notice to resume the service, nor has it been received by any of his NOK. It is also reiterated that the respondent authority have not furnished, made available the records of the proceeding of the so-called court of inquiry. 15, that after declaring the petitioner as a deserter with effect from 1/10/2016, in not considering the petitioner's representation stated such and such, praying for invalid pension as he was purportedly dismissed from service by the Brigadier DIGER with effect from 17/12/19 formal. After committing a so-called COI, the respondent authority have presently audaciously reached out to the petitioner by office letter dated, my lord, this is interesting. 16/1/2024. For what? For payment of the GIS, which was received by the petitioner by post on 4/3/2024. They are saying that I am a deserter. And I'm entitled for GIS. Not only that,
16/1/24.
yes. So they have asked for my all details, which I have already furnished to them.
That is after the WPC was filed.
The present petition. Then DPF batch para 16/1.
Final payment of GPF.
Yes. So GIS is entitled. GPF is entitled. In all this document, the petitioner submitted. It is that the petitioner is a person living with BLHIV. In the action of the respondent authority has been manifestly discriminatory, which has resulted in loss of employment and livelihood opportunity for the petitioner, which is against the provision of right of persons with disability Act 2016, wherein Section 24 provides no government establishment shall dispense with or reduce in rank an employee who acquires a disability during his course of his or service.
It's the one which you showed earlier.
Yes, they are totally oblivious about the act. On this ground alone, violation of the Act of Parliament, the Indian dismissal order that is and such liable to be quashed. So I am praised that the Indian dismissal.
So in this, you're praying for this, quashing of the dismissal order.
My lord.
If you have a copy of that judgment which you have quoted,
My lord, apart from that, I.
any other Supreme Court decisions also regarding non-supply of the proceedings? And then non-issuance of notice. There are so many. There's so
My lord, I am placing to 2019, this is wrote once.
Twenty 19 for GLT.
Yes. These are very short judgment of this court.
Yes.
This is why
You have
2019
copy.
for GLT 802. Only the noting, no?
You can bring it from the library, na? This one and this one.
I may be allowed to read.
Yes,
out,
yes.
my lord. This is Matan Chandra C.H. Nat, petitioner,
Mm.
versus Union of India by Justice Potishwar Singh. Heading is this. Service Law Disability Pension, CCS Extraordinary Pension Rules 1972. Of course, it was since pension comes under 1972 rules, but EOB rule is, if I'm not mistaken, 1939. Medical court permanently rendering the employee abusive and fit for further service after medical categorization in medical category, that is EEE. Yes, the petitioner completing only 5 years, my lord, in 6 months. Claim for disability pension under CCS extraordinary pension. Held for payment of pension under Rule 72. It is well settled that unless a person has completed 10 years of qualifying service, he will not be entitled to qualify for service. That is
10 years.
under the aforesaid rule, even for invalid pension, Rule 3.1, which I placed before your lordship. A of the CC's extraordinary pension rules indicates that a person can be granted disability pension if the disablement is due to injury or disease, my lord, which is attributable to the government service as provided under Rule 3A1, subclause 2, further provides that disability pension can also be given if the disability is found to have existed before or arose during government service and remains aggravated thereby. Medical report revealed that the petitioner would be entitled to disability certificate under Rule 3A1, a small a of the extraordinary pension rules. Direction given for grant of disability pension to the petitioner. Delivered. Then next one. The same volume, 831, 2019 4 GLD 831. This is just this schematic. Service law dismissal from service.
Is this the same citation you had given earlier, or this is different one?
Yes, state.
Already,
Yes.
yes, okay.
Dismissal from service on ground of desertion. Deceased government employee found untraced for more than 7 years. Disciplinary action taken by the department pursuant to which he was dismissed from service, and an ex-party proceeding, the same with the present case. Pensionary benefit to the dependents, claim for pension by 2 widows, whether admissible, legality, invalidity thereof. Under such and such, the person who was alleged not heard for 7 years upon the person who affirmed it. The court does not reveal that such burden has been discharged. Disciplinary proceeding initiated without any effort to find out whether the employee was alive held to be wholly insensible. Ex-party proceeding to bring an end to the service career of a person has seriously and adversely affects his dependents. Decision to proceed against the husband of the petitioner even without ascertaining his whereabouts, keeping in view that the missing report was lodged by the commanding officer of CRPF himself, appear to be devoid any logic cannot withstand the test of reasonability. impugn order of penalty of dismissal of service set aside in quas. Direction given to disperse this state come retirement gratuity, life engagement, family pension, and other retirement benefits. This was a case of somebody,
There also, he was not heard and dismissed.
my lord, in
Ex
this,
parte.
this is a bit different.
Mm.
The person, he was a driver.
Mm.
Then he went missing.
Ah, true, true, true.
Then they just held a so-called proceeding
Mm.
and dismissed.
Mm.
That is how the family, they were denied the
Mm.
pension. It's a short one, I may be allowed to read that.
Read the relevant para only.
12, 13, 14, and 16. 1, 2, 3.
Mm.
Only 3
Mm. Mm.
pages.
Mm.
To 12. The rival submission have been duly considered. The matter of fact of the case is that the husband of the petitioner is gone missing on 15/5/2008. In the same was reported by the commanding officer himself by looking at a fire on 15/5/2008. In the police case registered, the investigating agency has submitted the final report with the petition, which the petitioner had brought on record by filing an additional affidavit. The CRPF has in fact issued a certificate dated such as 5/9/2017, wherein it has been clearly stated that the investigation had culminated into a final report dated 25/5/2014. Until such date, the husband of the petitioner remained untraced. Two, in the court of inquiry, it has been concluded that the husband of the petitioner is deserted. Such desertion, in the legal sense, has to be animus diserendi, that is an act of willful desertion. In this then case, it does not appear that the husband of the petitioner deserted the force. On the other hand, the materials before this court leads to the conclusion that from 15/5/2008, the husband of the petitioner has gone missing and could not be found till date. Under section 108 of the Evidence Act, which has been quoted above, is upon the burden of proving that the person is alive or who has not been heard for several years. It lays down that when such a question arises for a person who has not been heard for 7 years, the burden of proving that he is alive as upon the person who affirms it. In the instant case, the record do not reveal that the opposite application was discharged by the respondent authorities before proceeding with either the court of inquiry or disciplinary proceeding against the husband of the petitioners. Though the said proceeding has initiated before expiry of 7 years, this court felt that it was wholly insensible on the part of the respondent authority as employer to initiate the disciplinary proceeding against such a person instead of making an endeavor to find if he was alive. Taking recourse to disciplinary proceeding that to ex parte is an easy way out, my lord, to bring an end to the service career of a person which has been seriously adversely affects on his dependents. Though this court is in agreement with the proposition of law advanced by the learned counsel for the respondent at this court in case of jurisdiction under 226 of the Constitution of India in a given case may interfere with the decision-making process, appear to be wholly unreasonable and arbitrary. In the instant case, the decision to proceed against the husband of the petitioner, even without ascertaining his whereabouts, in keeping in view that the missing report was lodged by the commanding officer CRPF himself appear to be devoid of any logic and cannot withstand the test of reasonability. In fact, such decision appears to be grossly arbitrary, which is the antithesis of the right to equality enshrined under Article 14 of the Constitution of India. Considering the facts and circumstances in the law laid down by this court by taking into consideration section such and such, this court is of the view that impugn penalty of dismissal from service stated such and such is not legally sustainable and consequently same is set aside. So direction was given. Now look, in your affidavit in opposition, they try to do some sort of a proceeding, which was not furnished to us.
In this 2019 for GLT 802, which were the paras which you had read out? That Justice Koteshwar's judgment. Paragraphs. Paragraph 11.
It appears that
11,
it's
12.
drafted only.
You were
Yes.
reading the head note.
Apprehension rule, page 20. Purportedly issued on 22/0 2017.
In their reply.
Opposition.
Reply now.
It is another one. Apprehension rule, absent without leave.
Page
Page 20 of their opposition.
20.
Yes. To SB, this is, another one is to
I'm
SB.
unable to
Page
find the affidavit in
page
opposition.
20.
Okay. Now this annexure 1
Yes,
to Superintendent of Police.
this is to SB.
Hmm.
This is for apprehension. Then 21. It appears to be the so-called court of inquiry.
The order.
Order of the commandant such and such. It appeal from Assam Rifle Nodal Hospital Headquarters IGR South on 1st October 2016. But one aspect of the matter kindly I may be allowed to submit.
But this is, their order is of 20th April 2017.
That is what. we are
Yes. So it is less than a year actually. Because the allegation is that you were a deserter since 1st October
That is
2016.
what we are saying.
Yes.
Yes.
And this is 20th April 2017.
Then what is the, I agree with the opinion of the court. This is the commandant of 32 Assam Rifle. Number such and such. Of this unit was referred to Assam Rifle Nodal Hospital Headquarters IGR South for his medical treatment. On 29 September 2016, an individual reported to ERH South on 30 September 2016. Further, he was referred to civil setup, that is RN's Papina Diagnostic Center, by the medical specialist to undergo a series of investigation on 1 October 2016, but the individual did not report back to ENRH and still so absent without information. After paying AWL, the individual did not try communication with his company in as well as battle and headquarters, 32 Assam Rifles. Guilty. Therefore, the individual only be blamed for this act. The court opined that number 7 such be declared as a deserter with effect from 1 October 2016 forenoon and struck off strength with effect from same day, and also with taken on supernumerary strength under Section 84, 1 of Assam Rifle Act 2006, Rule 183, 1, 2, 8, Clause 8 of Rule 2010. Identical number 7 such. Charge off from later charge as per the book. Distribution is to, not to the persons. That is my prayer. Whatever your lordship order, whatever be the way, but one fact remains that the person is he got sick while in service. Much of what?
Yes, Murli.
My pleasure, Your Lordship. My Lord, the present petitioner is enrolled on the Assam Rifle in the year 2003. While serving as a 32 Assam Rifle, he was treated as immunity, deputy surveillance, my Lord, at the year 2014. Under such circumstances, the present petitioner was under medical treatment for that week. And he availed 4 weeks leave also. Then thereafter, he reported back to the unit after 10 months. And then he was referred to Assam Rifle Composite Hospital, Sukhvi.
Till there, that it's all on record.
Yes, yes.
Okay.
On such circumstances, from Assam Rifle Composite Hospital, Sukhvi, he was referred to the Assam Rifle Northern Hospital for further investigations, specialized opinions, my Lord, to the Assam Rifle Northern Hospital, South. And from there,
Which is known as this IGAR South.
yes, ma'am. Yes. From there, he was further referred to Papina
Infal.
Diagnosis RIMS. Then that onwards, the petitioner has never reported back to the
Assam Rifle Nodal Hospital, nor a South, nor the Assam Rifle Composite Hospital, Sokui, and nor the unit. And whether he has reported today several hospital rooms or not, that one is not out of knowledge of the concerned authority, my lord. As such, my lord, the competent authority is inquiring about the present petitioner, where he is, where he was. And then thereafter, it is reported by the Assam Rifle Nodal Hospital South that the concerned person that presented petitioners has not reported back to the Assam Rifle Nodal Hospital. Therefore, the notice is communicated to the Assam Rifle Composite Hospital as well as their unit. So taking into account for this unusual absentee without leave from the bona fide duty, the concerned authority has inquiring about. As such, the concerned authority has write a letter of the SB Mokuchung as well as the administration and to his wife. And the concerned authority has issued rules to apprehend the to say the delinquent person that wants the present petition, my lord. However, the present petitioner is not arrested by the Bokun police as well as the several
Because he
authorities.
was living in Dimapur, no, not in.
No, my lord, that one is he's congratulated. My lord family is congratulated because his permanent address is Bokchong, Mangmido. Yes. So that his service record also it is written as that permanent address. So that of course
His phone
sometimes
number.
we have to shift here, and sometimes we used to shift here, so that one will not be taken into account.
And the
submissions of
notice on the wife, how was it served?
my lord, today, police as per the record, man. But the later, Nixon of Ken, his wife, replied to the notice and did not inform the whereabouts the present petition. No, there's several advances, my lord. And now, my lord, here, after doing all these things, at that time, he never applied for medical pensions and not apply for any beneficiaries. But after terminating his service from the service, now he is claiming for disability pensions and to to continue his service, so that after the lapse of so to say 7 years, and after termination of his service, that was after 4 years.
But can you say that the disciplinary proceeding or the court of inquiry was done as per procedure?
Yes, my lord. After issuing that apprehension rule, but we have not received any information about is, so that we comment inquiry, court of inquiry.
Ex parte.
Yes, because we don't find that very person because
Did
he is
you
attending.
serve any newspaper notice? Because the specific allegation is that no opportunity of hearing was given.
Yes, because he is attending himself
So for whether you have.
without leave. So that how can we call him?
No. Finally, if nothing works out, the
My
newspaper
lord,
notice has to be
if the
given.
person is not and that position, how can,
Okay.
yes, that is the case, my lord. So that we have issue apprehension rule. That one is my annexure one, my lord.
That I have seen, yes.
Yes. And then there are that we have not received any information where he was and where he is. So that inquiry was conducted, my lord. As under what circumstances the present petitioner is assenting himself without leave. Accordingly, that one is court inquiry is conducted on 20 April 2017. My lord, that one is so my lord friend has already
Yes,
submitted.
we've seen that. Then you come to page 22 of your affidavit in opposition. This is an extract from what? This annexure 3. Page 22, annexure 3.
My lord,
This is extracted from.
I'm referring to my affidavit of opposition and that petition number 114 here of 2023, my lord. Because this is do repeated petition.
Yes.
Which one I am referring is annexure 2, page 18, my lord. That court of inquiry conducted.
Yes, apprehension rule is page 17.
Apprehension rule is page 17, according to my written opposition and development in 140, 340.
314. Page 18 is the COI order.
Yes.
Then come to page 19. Page 19, annexure 3.
Yes, yes.
This is extracted from where?
That one is
You have referred to section 3 deserters, section 197. So this is from Assam Rifle rules. This Assam Rifle rules on 2010, or where is it from?
I'm referring to Assam Rifle Act 2006.
Do we have that here? Assam Rifle Act 2006. Because this is rules and regulation is there. This is rules. Oh, act is here. Yes. 197. No, this Assam Rifle Act 2006 is only till section 168. You cannot just produce any piece of paper and put it
My lord,
inside.
I'm referring to Assam Rifle Regulation 2016. 2000 Pro 197 sub Pro P.
60.
Be able, please, Your Lordship.
1 minute. No, it's here. I have it.
May I read?
1 minute. Yes. This is your annexure 3, page 19. Yes. You just go to 197, your 197B, cross B.
Yes,
A deserter who is not apprehended
yes.
or
Or who
fails
fails to surrender for a period of 3 years, and case of normal desertion, and 10 years in case of desertion with arms and ammunition, or desertion to a foreign country, may be administratively dismissed from the service under the order of the competent authority without being brought to trial by the Assam Rifle Court.
Yes.
Yes,
But the procedure has to be completed.
yes, yes.
Okay. What
So
else?
now, my lord, concerning the reply to the petitioner submissions, I would like to refer to my paravis comments. Page 8, paragraph 16, my lord. With regard of the WPC number 317K of 2023. May I read, my lord?
Yes.
That in reply to the amendment made by the petitioner and paragraph 5, the respondent submit that the petitioner was referred to Assam Rifle Composite Hospital, ARS, in September 2014, as I state, my lord. However, the petitioner absconded from there and reported to 32 Assam Rifle on 21st July 2015. That is after 10 months, as I've submitted before, my lord. After 10 months of his absence, my lord. That in reply to 17, that reply to agreement made by the petitioner in paragraph 6 and 6.1, the respondent submits that the petitioner was admitted at Assam, that one is the Assam Rifle Composite Hospital, my lord, Sukhumvit on 14/12/2015, and was discharged from the hospital with 4 weeks sick leave. As I stated, here I will 4 weeks sick leave. And he was again admitted at Arts Sukhumvit on completion of sick leave and discharged from the hospital on 18/3/2016. Like discharge summary, that annexure of the red petition, my lord. It's my learned friend has an annexation that is red petition, my lord. Now comes to paragraph 19, my lord.
Yes, yes. What's time? Let's resume it. How long will it take? Half an hour?
The short time.
Yes, you were referring to page 9. Only.
May I continue, Your Lordship?
Yes, yes.
My Lord, I'd like to refer to my affidavit of position, paragraph number 17. That is a reply, that in reply to the amendment made by the petitioner and paragraph 6 and 6.1, the respondent submits that the petitioner was admitted at Arch, Sukhumvit on 14/12/2015 and was discharged from hospital with 4 weeks sick leave, and he was again admitted Arch, Sukhumvit on condition of sick leave and discharged from the hospital on 18 March 2016 by discharge summary dated 18 March 2016, as reflected in the result of my learned friend petition, my Lord. Now comes to my Lord, paragraph 19 of my affidavit of positions and WPC number 314 of 2023, my Lord. This is very important, my Lord. That with regard to paragraph 7.4, the respondent submits that the petitioner was referred to Arch, Sukhumvit for medical review. For medical review, my Lord. And as per discharge summary dated 18 March 2016 and recommended to be placed in medical category B3 under bracket D24 for his disease immune surveillance. And accordingly, medical board proceeding was convened like medical board dated 21st March 2016 and the column 9 of the EPIT board proceeding coded that says duty on 18 March 2016, which means that the petitioner was temporarily relieved from his general duty for his treatment and further management during the period of treatment only, and which does not mean that he was totally relieved from attending general duty and other duties, my Lord. It is further submitted that thereafter the petitioner was detailed engaged in the duties as per the job restriction prescribed for B3 under bracket D24 medical category persons and Assam Rifle order 290. It is also pertaining to mention here that disability invalid pension is only applicable to those who are invalided out from service on the medical ground. However, in this instant case, the petitioner was not proceeded on invalided out from service, but he deserted from service, and accordingly, 3 years later, he was dismissed from service. Roll 24 of Central Civil Service Pension Roll 1972, Annexure 6.
Annexure 6, page 23.
My Lord,
I think it's 4, annexure 4.
for-
Annexure 7,
that one is page 24, my Lord.
page 24.
Yes, annexure 7. I mistakenly referred to annexure 6. That one is 24, roll 24, forfeiture of service, dismissal or removal. May I read, my Lord? Dismissal or removal of a government servant from a service or both until forfeiture of his past service. That one is my annexure 7, page 24, my Lord. As the petitioner was dismissed from service with effect from 17/12/2019, being deserter, service rendered by him stands forfeited, and as such, he is not eligible for any pensionary benefit. Hence, this petition is liable to be rejected by law. My Lord, come to the paragraph 21.
That in reply to the amendment made by the petitioner and paragraph 10 and 10(1), the respondent submits that the petitioner absented without leave from service on 1st October 2016 and subsequently, as per opinion of the duly constituted court of inquiry, the petitioner was declared a deserter from service with effect from 1st October 2016. My lord, that's we have discussed. He is referred to the Assam Rifle Nodal Hospital, South, and from Assam Rifle Nodal Hospital to the RIMS, Terminal Diagnosis Center, my lord. But he is not reported back to the Assam Rifle Nodal Hospital, nor to the Assam Rifle Composite Hospital, nor to his unit, my lord. So the consequence arrived at this conclusion, my lord. The detail of his admission and discharge from the hospital occurred during his desertion period. And the respondents have no knowledge regarding the same. However, it is also worth mentioning here that the petitioner had an opportunity to rejoin on duty after his discharge from city hospital, my lord. As my learned friend has stated that he is taking treatment from the civil hospital. However, he intentionally remained absent from duty and has now approached the honorable court after 7 years. As I stated, my lord, he is coming to the court, taking advantage of this flimsy grounds, my lord. With 7 years with flimsy ground to cover up his lapses and grab undue service benefit from the honorable court. Hence, this petition is liable to be dismissed and infractions. My lord, paragraph 23 of my affidavit of position, that while denying the correctness of the statement made by the petitioner, and paragraph 12.1 and 12.2, the respondent submits that the petitioner was absented without leave on, as I stated, 1st October 2016, and later, as per procedure, he was declared deserter with effect from 1st October 2016, as per the opinion of the court of inquiry. However, before initiating procedure to declare the petitioner as deserter from service, an apprehension rule was issued, right? 32 Assam Rifle is, I have annexure 1, that the apprehension rule was issued to the petitioner, but he is not complying with it. And even if the state police, nor the state administration has committed any indemnifications to the authority concerned, my lord. And even his wife also has not acknowledged that apprehension rule. A copy of the appraisal, that one is I have an annexure at my annexure 1 of page 17. That one is apprehension rule. That one is issue on 20 February 2017. As per procedure and link, on completion of 3 years of desertion, the respondent number 5 has issued 2 letters to the petitioner and his wife, annexure 5, and provide him a last chance to report on duty and advise to report on his unit within 1 month. 1 month on receipt of the letter, and categorically warn that if he fails to retreat duty, he will be dismissed from service. That one is on conditions of paragraph 23, my lord. Which one I'm reading. However, the petitioner did not give any response to the letter, and on completion of 3 years from the date of desertion from service, duly completing all legal formality, the petitioner was dismissed from service. It is also pertinent to mention here that the petitioner has intentionally deserted from service and not responded to communication made by the respondent. Hence, it is clearly established from the above that the
that the respondent gave the petitioner totally intact about his dismissal from service, etc., are blatantly false and baseless. My lord, now comes to paragraph 26 of my petition of position. May I read, my lord?
Yes.
That ever met by the petitioner and paragraph 12.5 and 13 are denied being false. It is submitted that the petitioner was provided ample opportunity to rejoin treaty by respondent letter dated 20 February 2017 and 11 August 2019. However, he did not utilize the opportunity and intentionally continuing desertion. The respondent was not in a position to serve additional cost to the petitioner due to his desertion, and also there is no provision provided in law to issue so-called notice to deserter from initiating administrative action against him. Subsequently, on condition of 3 years, the desertion, all formalities were completed, and then petitioner was dismissed from service with effect on 17 December 2009, order dated 17/12/2019. Hence, the petition of the respondent to dismiss him from service is legally valid and is not liable to be interfered. So we have been given number of times opportunity to rejoin the treaty, but the petitioner has never responded to our correspondence, and he never joined his normal treaty, and he is abstaining himself from the treaty, my lord.
Yes.
This one, the annexure 5, page 22. That one is dismissal and respect of person of deserter absent without leave or overstaying leave. Please refer our attention roll number such and such, that such and such. It is indemnified you that you have been absent without leave from RNH headquarters IGS as on 1st October 2016 without giving any information to this unit, my lord. As I said, without giving any information to the unit as well as to the hospitals, the petitioner is absenting himself. Just normal treaty, my lord. You have been declared deserter with effect from 1st October 2016, and casualty has already been published by our daily part 2 order numbers such and such dated 25 April 2017. As per the implementations of Assam Rifle Regulation 2016, that is before 18 November 2016, and Vic giving a final letter to individual stating that a final opportunity to rejoin his service within 1 month around the shape of the letter, failing which the provisions of para 197 of Assam Rifle Regulation 2016 will be applicable, and the individual will dismiss from service on completion of 3 years of the deserter. Absent without leave, AWL, OSL, my lord. Hence, you are advised to rejoin treaty within a month. So that we have communicated to the petitioner a number of occasions, but he is not responding to the information. And then there are the now candidate paragraph 28, my lord. That ends, may I read, my lord?
Yes.
That in reply to the amendment made by the petitioner in paragraph 15 and 16, the respondent submits that the petitioner absented himself from duty and never reported back to the unit, and accordingly, after 3 years of lane period, he was dismissed from service as per the rules. Pensions to some rifle personnel are being governed by Central Service, Central Stable Service Pension Rule 1972. That one's which one I have a reference. That one is annexure and my annexure. Annexure 6. That one is
Yes, yes, we have already referred.
yes, yes. As the petitioner was dismissed from service with effect from 17 December 2019, being deserted, and thus service rendered by him stands forfeited, and as such, he is not eligible for any pay and allowances and pensioner benefit. Moreover, the petitioner was paid even after his desertion till February 2017, and he is liable to deposit this overdrawn salary amount being to rupees 2,27,960 payment made to him. Paragraph 29, my lord. That the evidence made by the petitioner and paragraph 17 and 18 are submissions of petitioner out of the knowledge of the respondent. Hence, no comments are offered. However, it is submitted that the petitioner was referred to several institute RIMS, Patina Diagnostic Center, by medical specialists, Assam Rifle Nodal Hospital to undergo detailed investigations on 1st October 2016. And after the medical investigation, the petitioner was required to report back to the Assam Rifle Nodal Hospital or his unit. Had the petitioner retained the duty, the respondent would have provided him better treatment at the service hospital and Assam Rifle Hospital free of cost, and also provided him pay and allowances. My lord. In the instant case, the petitioner intentionally continued his desertion from service and not responded to the communication made by the respondent. Subsequently, after completion of the length period of 3 years and after complying all the necessary legal formalities, the petition was dismissed from service. Therefore, there is no ground available with the petitioner warranting the interference of the Supreme Court. Hence, the petition is liable to be dismissed. And there is justice. My lord, my last submissions, that one is a paragraph 30. That the evidence made by the petitioner at paragraph 19 are denied being false statement. That is submitted that the petitioner had been drawing his monthly salary up to the month of February 2017, my lord, and had overdrawn an amount of rupees 2,27,960. As he was not entitled to any pay and allowance with effect from his date of desertion. That is 1st October 2016. My lord, as such, the petitioner has no entitled to invalidation and to release their pay and allowances and to grant disability pensions because of his act, my lord. And regarding the petition number 214, I am completing my submission from there, my lord.
Mm-hmm. 71.
71, my lord. May I proceed, my lord?
Yes.
My lord, as far as I have submitted my affidavit of opposition in respect of WPC number 315 314 the officers and similar nature, my lord. As
Yes.
such, but here,
Almost same the next years also.
yes, my lord.
Yes.
Yes, my lord. But there is some differences here, my lord.
Mm.
My lord,
Here
my-
the dismissal is challenged. Dismissal and then the court of inquiry.
the question inside it is not order,
Yes.
my lord. So, my lord, as I have submitted before, the petitioner was diagnosed as immune surveillance during his annual medical examinations in 2014. And then thereafter, he was undergoing medical treatment and from the unit. And then thereafter, my lord, he is referred to Assam Rifle Composite Hospital to Sukuri. And from there, he is referred to again Assam Rifle Nodal Hospital, South. From there, my lord, the petitioner has referred to RIM, several institute, that one is Papina Diagnosis Center, my lord, for special investigations. While he was referred to that institution, he never came back and reported the Assam Rifle Nodal Hospital, South, as well as he never reported back to the Assam Rifle Composite Hospital, from which he was referred. But he has not reported to that Assam Rifle Composite Hospital, and later he reported back to his unit. And now he is absenting himself from government bona fide duty. If he's reported back to the Assam Rifle Nodal Hospital, it will come to know that the committed authority that he is under such a medical treatment. But while he's referred to the several institute, he later reported back to the Assam Rifle Nodal Hospital, nor the Assam Rifle Composite Hospital, and the unit in his unit. So this the unit is, and the Nodal Hospital, Assam Rifle Nodal Hospital has reported to the Composite Hospital as well as the unit. So the issue arises from there, my lord.
What is this preliminary objection? Filing a petition without making disclosure. I think that issue you cannot raise because during the pendency of this 314,
yes,
a new cause of action arose because the dismissal order came about. Only then they knew about the dismissal order. Only when 314 was filed. That's why they had to challenge this dismissal order.
Yes, my lord, that one is, this issue is that we have communicated through certain matters, but he is not responding to that. As I have stated that his permanent address is Mokosung.
That is a disputed question.
Yes, his permanent address is Mokosung. Maybe he is residing somewhere else with his family, but he never entered that his present address
But
to
whether
the
police
service.
had
his
also
service.
duly served or not, whether you had also taken steps by notice in the papers or not, that
No,
also-
no, my lord, that one is particular and as grateful. This paramilitary, they are not publishing that local newspaper and as well as the newspaper, all these things, because there is a security reasons, man. So
no,
all these
notice,
things.
notice, even,
We are not
even police is doing that.
Yes, my lord, that one is for police.
Because,
different, my lord.
because all
This,
the options have to be exercised, no? All the options have to be exercised
army authority
to
will
make
provide
sure
that,
that it reaches him.
my lord, on that case to
Anyway.
paramilitary,
yes.
we're not doing all these things, my lord.
Because how do you know that the police had also served when he's not living there?
For
Some
security
sort of-
reason also that we have notice
And
to
for
apprehend
example,
them.
even when we serve summons in the court, in the trial courts, we serve it through the police and we get the acknowledgement from the police, isn't it? So you didn't get any acknowledgement from the police that's regarding the service of notice.
Yes, my lord.
So how can you say that it has been served? Anyway, it's just discussion.
So that due to this declarations, and he is not as my lord friend has stated, he didn't intend to continue his service, so that he may be absenting himself without leave. That
Yes, then come to your affidavit in opposition. What have you stated in response to their allegations about non-serving of notice, non-serving of the concerned proceedings?
No, my lord, actually, we have served notice to his wife also.
That also through the police. That also through the police, through the OC. Both through the police, OC only.
My lord, my page 27,
Page 27.
Annex 6. Particularly, we have mentioned Srimati Ainla Imchin, Nix of Gate, wife of number such and such, rifleman, General Duty Empong Sanen Ao, Village Mangmitung, PO Mokchung, BS Mokchung, District Mokchung, State Nagaland, PIN such and such. We have communicated the event to
Yes,
his
and
wife.
at the bottom, copy to OC. So this was served through the OC, OC of Mokchung, PS. That also Mokchung has 2 police stations. Nothing is indicated. It just says OC police station, Mokchung.
So that now may I read the paragraph 17, page 12 at 10 of my affidavit of opposition.
Para 17.
Yes,
Yes.
may I read, my lord?
Hmm.
That in reply to the argument made by the petitioner and paragraph 4.3, the respondent submit that they do not deny that the diagnosis of HIV was conducted when the petition was in service. However, on basis of point 3 of the opinion of medical board proceeding held on 21st/3/2016, Annex 5 to the petition, it is clear that contradiction of HIV is later attributed to the conditions of service, nor aggravated by the service conditions. My lord, by referring to the red petitions Annex 5. This is the opinion of my learned friend petition, Annex 5, page 36. 35 from 35 to
35,
36.
starting from 35 and 36.
Yes. That
Yes.
36. Opinion of the board, part 2. C. 1, 2, 3, cell number 3. If directly attributed to conditions of service, if so, by what specific conditions? So that non-applicable. It is written that non-applicable. So that he is not totally says from general, he is given relief from general duty, but he is not totally says his duty manual. This one is very much relevant one. Now come to paragraph 15, my lord. May I read, my lord?
Yes.
It is that in reply to the argument made by the petitioner in paragraph 5 and 6, the response submits that the petitioner, he was referred to Civil Institute RIMS Papina Diagnosis Center by medical specialist Assam Rifle Nodal Hospital for detailed investigation on 1st October 2016. But the petition later reported back to the Assam Rifle Nodal Hospital nor to the unit, and remain absent at children without any information to any authorities. Therefore, as per procedure and leave, and absent without leave, report was originated from Assam Rifle Nodal Hospital to all concerned. That after expiry of 30 days of his unauthorized absence from government bona fide duty, an apprehension rule was issued by 30 Assam Rifle, like their letter number such and such, dated 20 February 2017. Though the Superintendent of Police, Mokshong Nagaland, and all other concerned authorities apprehend the petition, as I stated, my lord. A copy of the apprehension rule was also forwarded to Samati Ainla Imchin, wife of the petitioner, with request to advise her husband to rejoin duty at 32 Assam Rifle at the earliest. However, he was neither apprehended by the police nor any intimation was received about his whereabouts from several administrations as well as from his wife. That the petitioner continued to remain absent from duty, hence, as per the procedure and leave, a court of inquiry was convened by the Commandant 32 Assam Rifle under the provision of Section 84 of the Assam Rifle Act 2006 to investigate into the circumstances under which the petitioner was referred to as Sukuvi by the unit hospital for medical checkup. But the individual did not report to the hospital and was absent without leave from our Assam Rifle Nodal Hospital, headquarters IGAR South. The duly constituted court of inquiry, after examination of available record and statement of witnesses, had opined that the petitioner be declared as a deserter from service with effect from 1st October 2016. Therefore, as per opinion of the duly constituted court of inquiry, the Commandant 32 Assam Rifle declared the petitioner deserter like order dated 24 2012, annexure to page 21 is that an annexure, my lord.
Yes.
For your kind
That's
reference.
the order.
Yes.
Order of inquiry.
Yes.
The court of
My
inquiry.
lord, reflected.
Yes.
However, as per the procedure, he was kept on supernumerary string under Section 84(1) of Assam Rifle Act 2006, Rule 183(1) of Assam Rifle Rules 2010 for a length period of 3 years, and accordingly, pattern routine order for his detention was published by 32 Assam Rifle, order number such and such dated 25 April 2007. However, the petitioner was neither apprehended by the police authority nor any intimation was received about his whereabouts from civil administration as well as from his wife, nor he surrendered himself thereafter. He remained absent from duty as per provisions contained and para.
Yes, this is the deserter one.
That one which I have
Yes.
reflected earlier. And it's hence expiry of 3 years and period, length period from date of the desertion, the petition was formally dismissed from service by Deputy Inspector General, Headquarters 7th Sector, Assam Rifle, by order number 8-dismissal order /32 ARIA such and such dated 7/12/2019, annexure 4, and terms of section 11 to section 11 subsection 2 of Assam Rifle Act 2016 read with rule 710 and 20 of Assam Rifle rules 2010 after fulfilling all cartel formalities. That it is pertinent to mention here that prior to initiating the dismissal procedure, a final letter was issued to the petitioner, next of kin, and OC Police Station, Mokosung Light 32, Assam Rifle, letter number such and such, dated 11 August 2019. That once the annexure, as I reflected. And next to 5 and 6.
You followed.
Yes, this first one is the person, the petitioner, and the second one is his wife, which we have communicated about the things. When he was specifically advised to report to his unit within 1 month on receipt of the letter as last chance, and was categorically warned that if he fails to return duty, he will be dismissed from service. However, no response to the letter was received from the petitioner or his wife, and he remained absented from government bona fide duty. Subsequently, on completion of 3 years of desertion, the petitioner was dismissed from service with effect from 17 December 2019 by headquarter 7 sector Assam Rifle. White order dated 7 as referred after completing all legal and administrative formalities, my lord. So that number of chances given, but that the petitioner never kind to reply and never acknowledge that correspondent communicated to him, my lord. And now he is coming to claiming all these things, my lord. And now come to paragraph 19 of that with regard to the amendment by the petitioner and paragraph 7, 8, 9, and 10, the respondent submit that the petitioner approves respondent do for grant of invalid pension by represented such and such, and the same has been suitably right letter dated 29 September 2013. And it should be answered. And it has been duly stated that as per Central Civil Service pension role, invalidation is only entitled to persons who were invalidated out from service on medical ground. Whereas in this instant case, the petitioner was dismissed from service as deserted from service. It is further submitted that the petitioner was absented without leave on 1st October 2016, and later, as per procedure, he was declared deserter with effect from 1st October as per opinion court of inquiry. However, before initiating the procedure to declare the petitioner as deserter from service, an apprehension rule was issued by 32 Assam Rifle to the Superintendent of Police, Bokshong, and all other concerned authority to apprehend the petition, as we have stated.
Yes, all these are repeated repetition.
A copy of the apprehension rule was also forwarded to Srimati Engine, wife of Nexus Scan, of the petitioner with request to direct her husband to return duty at 32 Assam Rifle. However, the petitioner did not respond to the communication made by the respondents, and intentionally continued his desertion from service. As per procedure MV, and completion of 3 years of desertion, the respondent 4 has issued 2 letters to the petitioner and his wife, Samati Enla Imchin, and provided him a last chance to report on duty and advise to report to his unit within 1 month on receipt of the letter. And category 1 that if he fails to return duty, he will be dismissed from service. However, the petitioner give any response to the letter, and on completion of 3 years from the date of desertion from service, duly completing all legal formalities, the petitioner was dismissed from service. This also pretend to mention here that the petitioner has intentionally deserted from service and not responding to communication made by the respondents. Hence, it is clearly established from the above that the agreement that the respondent kept the petition totally in dark about his dismissal from service, etc., are blatantly false and baseless.
Any case laws, because all these are same repetitions on all your paragraphs.
Yes, my lord, that one.
The only ground that 2 notices already given that the court of inquiry was held, then only declared after 3 years declared deserter. Same thing. Any case laws?
My lord, here and preliminary objections. That one is a paragraph 13. Tele and lectures.
Paragraph 13.
Yes.
Yes.
Page 7. Page 7 of paragraph.
Yes.
13 married, my lord. Delay in latches. The petitioner has deserted from service with effect from 1st October 2016 and has approved the Honorable Court after lapses more than 7 years of his desertion from service. Yes, as said, my lord. Then alternate delay of more than 7 years has not been cogently explained by the petitioner and the red petitions, my lord. Hence, the red petitions suffer from the principle of delay in latches. As such, the answer red petition is barred by law of limitation and is liable to be dismissed on this sole ground. Following red petition have been dismissed by the Honorable Court for the reason of delay in latches and the present recent past. Judgment dated section May 2013, pass and WPC number 329/2012, filed by Sri Bahalman Rai, the Honorable Gauhati High Court, held that since the present petition has been filed after a period of nearly
Is this a reported
30
case?
Yes, my lord.
Where is the citation?
My lord, I'm sorry to.
You have not brought the
Yes,
citation
my lord.
then? And what about this second one? High Court?
Second one,
This one also?
that one is, yes, this one also. I'm just relying the,
No, just relying by way of pleadings will not do. You have to produce the particular citation, the judgment.
so that A and B, that preliminary delay in the latches are referring to this due judgment. The High Court.
Any
of the
judgments
immediate-
on delay, empty. Any judgments on delay, because this is after 7 years. No?
The president is not the,
Not sleeping over.
no. It's not a question of delay because the fact remains that
Oh, you didn't know about the
it is
dismissal.
that the petitioner who have been getting treatment on his own. It was as per the procedure in the union where he was diagnosed with the sickness. So my learned friend is very fair in saying that about the treatment. He's very clear about it. From 32 ER to Sukubi to no to hospital. So we are very clear about the medical condition of the patient. When he conducted the court of inquiry, just see that, take the words view of the matter, that I am a deserter. In that case, the witnesses to be examined.
No, that I've already taken note of.
Yes,
But when you came to know was only in 2023.
yes.
When you submitted your application for invalid
My lord.
pension. Na? So from 16 to 23,
See, about
18, 19,
Yes.
20, 21, 22, 6 years, say 6
Yes.
years. What made you file that invalid pension application only after 6 years?
my lord, I've stated clearly that the petitioner is not in proper frame of his mental. It is his elder brother,
Okay.
staying in Mokong,
Mm,
who have contacted some lawyer.
mm.
Then only it was referred. Just see my page 42, the condition of the petitioner. I've received this copy when 314 was
Right.
filed.
Mm.
And it was furnished to me only in the courtroom. Even after I informed him, because of the health complication,
Mm.
he could come up on 16 to 24.
Yes. You said that you accepted the
Yes,
copy
I-
and then you served to give it to him.
My seal is there. received.
Yes. Okay, okay. Yes, please continue. Yes.
Yes, my lord, that alien ledges, and my supera B. That one is referred to the Honorable High Court, Delhi, New Delhi.
So where is that?
Our,
How
Is
can
that
we
at
just
my-
quote,
my
how can you
submission, ma'am?
just quote judgments and not produce? Can you give it today? Supply it today?
about this.
Otherwise, how can we refer to that? The court cannot refer to something which is just noted in the pleadings and then we do not have the judgment. Anyway, next. So your preliminary objection is on the delay and then saying that second writ petition on the same grounds.
Yes, yes.
Then what else?
Then, I want to say that the paragraph 20 of my affidavit of opposition.
Paragraph 20.
Yes, page 14, my lord. In conditions of my sanction.
Yes.
The government made by petition and paragraph 10(1) of and 10.2 are not agreed, as that after expiry of 30 days of his unauthorized absence from government bona fide duty, an apprehension roll was issued by the judge Assembly that such and such dated 20 such and such. The Supreme Police, as I was stated, Mokchung, and all other concerned authorities to frame the petition. A copy of the apprehension roll was also forwarded to 70 and Mchin, wife of the petitioner, with the request to advise her husband to restrain duty at 32 as rifle at the earliest. However, he was later apprehended by the police, nor any information was received about his whereabouts from the civil administration as well as from his wife. That the petitioner continued to remain absent from duty. Hence, as per procedure, the court of inquiry was convened by the Commandant 32 as rifle under provision of section 84 of that one is reflected by my land friends Assam Rifle Act 2014 to investigate into the circumstances under which the petition was referred to as Sukuli by the unit hospital for medical checkup. But the individual did not report to the hospital and was absent without leave from ARNS headquarters IGR South. The duly constituted court of inquiry, after examination of available record and statement of witnesses, and had opined that the petitioner be declared as deserter from service with effect from 1st October 2016. Therefore, as per the opinion of the duly constituted court of inquiry, the Commandant 32 as rightful declared the petitioner a deserter flat ordered that is such and such. That one is my annexure 2. However, as per the procedure, he was kept on supplementary strain under section 84(1) of Assam Rifle Act 2016, Rule 183, subclause 1 to subclause 8 of Assam Rifle Rules 2010 for 11 period of 3 years, and accordingly, battalion routine order for his desertion was published by Assam Rifle Order number such and such dated 25/4/2017. However, the petition was later apprehended by the police to know any information was received about his whereabouts from civil administration, as well as from his wife, or he surrendered himself thereafter. He remained absent from duty as per provisions contained in para 197B of Assam Rifle Regulation 2016. Deserter who is not apprehended or who fails to surrender for a period of 3 years in case of normal desertion, and 10 years in case of desertion with arms and ammunition for desertion or desertion, and 10 years in case of desertion with arms and ammunition or desertion to a foreign country, may be administratively dismissed from the service under the order of the competent authority without being brought to trial by the Assam Rifle Court. That one is my annexure 3, my lord.
Same submissions, Mr. Nguli,
Yes, my lord.
as in WPC 314. Yes. Anything else? Any new grounds?
What, that much similar to the WPC number 1314 key of the system and 71.
Are you relying on any authority, any authorities?
My lord, that which I have
Those two judgments which you have referred in your affidavit in opposition, you don't have the
Yes, yes.
judgment. Any reply?
Petition which I have extracted. My lord, this Assam Rifle Act,
Hmm.
1683.
I think this is already on record. This one, maybe you supplied earlier also.
Yes.
Om Datta Sharma.
What I'm trying to see is this. If somebody is a deserter,
Hmm.
they should be captured in tried.
That's what I was telling them.
Yes.
Since he was not in Mokchung, that's why the police also could not apprehend him.
Section 83 is clear about it. It should be, if it knows somebody is a deserter, it's a serious matter in armed forces. So the moment somebody is a deserter, he should be captured in tried.
This is on what proposition? Which
My lord,
legal proposition?
non-supply of the
Non-supply.
documents.
Okay.
In this case, not even a single document was given. At the same time, in their affidavit also, it is not inclusive. What was the proceeding? Much obliged.
Even in affidavit, nothing is
No.
enclosed. Heard learned counsel for the petitioner, Inti Longchar. Also heard learned CGC, Mr. Zedem Muli. Judgment is reserved.
Much obliged.
I'll keep this for some time.
My lord,
This one, I'll return it later, okay? Because we don't seem to have this in the library, huh? This Assam Rifle Regulation, Assam Rifle Act,
it's available in the what
online.
online.
Mm.
I do not print it
Acha,
out.
acha, acha. We should also print out and keep in the High Court, no?
For hearing item number 25.
My lords, I'm appearing for petitioner in item 25 and 26. My lords, as per the... May I continue?
Yes, yes.
My lords, as per the last order, the respondent number 1 was supposed to file their affidavit in reply. However, as of today morning, we haven't received any reply in both the matters, in 25 as well as 26.
But who's appearing for the respondent? CGC. The CGC was just here. He left.
Oh,
Nobody is
my
there.
lords,
We'll fix another date.
Yes, my lords. My lords, just a request. The interim order may be continued till the disposal of the matter.
Yes, yes. Learned counsel, you are?
Counsel for the petitioner, Rishabh Jain.
Learned counsel for the petitioner, Mr. R. Jain is present. However, none appears for the respondents when the matter is called. Stop. Learned counsel for the petitioner also submits that the respondents were allowed time to file affidavit in opposition.
Yes, my lord.
To file affidavit in
It
opposition.
was only directed to respondent number 1.
Okay, okay. That the respondent number 1 was allowed to file affidavit in opposition. Stop. However, the same has not been received by the petitioner till date. Stop. Accordingly, list the matter. When? Any fixed date you want, or we'll put it next week?
My lords, if the reply, like if they want to seek time to file reply, then after the reply. But if not, next week is
Okay, we'll see it after 3 weeks then. List the
3
matter
weeks.
after 3 weeks.
Yes, my lord.
Meantime, the learned counsel for the respondent number 1 shall file the affidavit in opposition if so advised. And the interim order passed earlier shall continue till the next date. List of the 3
My lords, till the disposal of the matter, interim order.
weeks. Just say till the next date.
Obliged, my lords.
Yes.
My lords, what was the next date?
After 3 weeks.
3 weeks. Obliged, my lords.